let's now take another law that comes into play, and that's polygraph testing. Okay? Polygraph testing. And what is polygraph testing? Drew?
Essentially, it's like these connectors that they hook up to you that like emit some type of like electric pulse that basically determines whether you're nervous or not.
Yeah.
And says if you're lying.
Yeah, they put these things on you, and you're hooked up to a machine, and they ask you a series of questions, and they try to determine from that and your reaction and response to that whether or not you're lying. Most of you are probably young enough that you have not had a polygraph test, but has anybody had a polygraph test? Anybody undergone a polygraph test? And the reason I say that is because most of you being young enough that it has been, for the most part, it is no longer proper in the private sector, okay? Worked years ago at a groceries. In fact, while I was here in undergrad, worked at a grocery store called Smitty's. Okay, I don't know if you all remember the Smitty's chain. And one night, and we're talking years, okay, years and years and years ago before this act, and money came up missing from a cash register, and basically they brought everybody that was on duty that night into a room and gave us a polygraph test. And the way it works, I mean, you may see fancy stuff. There was some show, one of these reality shows a couple, 3-4 years ago, just probably the worst one I think I've ever seen, but can you tell whether somebody's lying? And they'd ask you a series of questions, and they'd bring your fiance on and ask you whether you really love her or what. And then, I mean, it was absolutely a bizarre show. It didn't last very long, okay? But really, what they do in a lie detector test, before they ever ask you the question, they tell you what questions they're going to ask you, okay? And the reason for that is to kind of get a baseline how you react, and they tell you what they are so that you can know and be prepared for the question, because they don't want the surprise coming into play in your response, okay? But basically, in 1988, there was an act passed called the Employee Polygraph Protection Act. And somebody asked, other laws, and we've kind of been talking about some of those, but other laws that affect privacy, or one of those laws is the Employee Polygraph Protection Act. The Employee Polygraph Protection Act. Bottom line, the Employer Polygraph Protection Act tells employers you cannot have your employees be forced to take polygraph tests. That's a federal act. Most states have a similar act. Right? Remember earlier where I told you that the public sector generally has more rights? The Employer Polygraph Protection Act does not apply to the public sector. All right? The Employer Polygraph Protection Act does not apply to the public sector. Why? I don't know. Don't know. And I think maybe the idea, if you're working for the government, we want to make sure that you're honest or whatever, and we want, it's important. We're using governmental funds. I'm not sure necessarily the reason that. I think that's part of the rationale. But it does not apply to the public sector, okay? You can be in violation. I always told my employer clients, don't even ask, because you can be in violation of the Employer Polygraph Protection Act if you even ask an employee to submit to a polygraph or lie detector examination. Now, why would the Employee Polygraph Protection Act say it's wrong to even ask? Melissa?
Because if they say no, you assume they're lying.
There you go. If I get 4 people in a room and 3 of them say, sure, I'll do it, because they think they have nothing to hide, and the one says they won't, who do I think is going to be guilty? It's the one, all right? And so the Employer Polygraph Act Protection Act even says you can't even ask if you're an employer for somebody to take a polygraph test. Can't even ask. All right? There are some exceptions, as there are with every law, and there are a couple of exceptions to the Employee Polygraph Protection Act. Where do you think some of these may be? Where might I be able to have people give polygraphs? Troy?
Government contracted jobs.
Yeah, national security. Well, probably it's got to be a little more specific than government contract job. Corey says government contracting jobs, and you're right, but mostly with regard to national security contracts. Okay, so there are exceptions for employees of contractors for national security intelligence operations. Why would we have an exception for that? Anybody? Because of national security. Okay. All right. Likewise, private security firms. Private security firms. Okay. They're allowed to give their employees polygraph tests. Bless you. All right. Employers engaged in the manufacture or distribution of controlled substances. So if you're going to go work for a drug company, manufactures or distributes, that company is accepted from the Polygraph Protection Act, and they can ask you to take a polygraph. And then here's the last exception, which would apply to most employers, but I always said, just don't risk it. The last exception is if you are an employer who reasonably suspects that employees were involved in an incident resulting in economic loss. Okay? If you're an employer who reasonably suspects that your employees or one of them have engaged in an incident which caused you economic loss, then you can administer a polygraph test. But let me say this. Merely being at the scene when the theft occurs is not reasonable suspicion. All right? So now, back in 1980, 81, 82, whenever it was, that I took the polygraph for Smitty's, I took it because, not because I ran the register that night. I took it because I was on the premises working, okay? They would not now be able to give me a polygraph test because they didn't really have a reasonable suspicion that somebody stocking eggs or whatever it was I was doing that particular night would be able, was stole money out of a cash register, okay? So you have to have a reasonable suspicion. Now, can you say, well, I asked them if they would take a polygraph test. They said no, so now I have a reasonable suspicion? No, because even asking to set that up, all right, and there's just, and you just don't hear of employers doing it very much because the risk is just way, way too high, okay? Penalty can be up to $10,000, and you don't want to have to be paying that if you're managing. And in addition, if you fire somebody because they won't take a polygraph test or because they flunked it and you didn't have that reasonable suspicion, now they get to be reinstated. You get wages, benefits, costs, all of that. So again, it's just too expensive. And polygraphs just haven't been proven reliable enough. Now, are they still used? Sure they are. Sometimes law enforcement will use it to try to clear somebody of suspicion. Okay. Any questions about that act? All right. Well, let's get back into where we kind of started with this whole idea of privacy, and that was communications, emails, monitoring, things of that. And we had a couple of questions over the weekend with regard to cell phones and what people can do and monitoring that. So let's talk about a couple of things. Why, again, the reasons we talked about, I think, last week with regard to privacy of the employee or the protection of the employer versus the privacy of the employee is you want to know what your people are doing with your equipment. You want to know where they're going. You want to know that you're not going to get viruses into your equipment. You want, I think, as Amanda said, to make sure your employees are productive. The other thing is you just don't, you don't want these lawsuits out there. In the Rodney, you remember the Rodney King, right? The beating in Los Angeles. In that case, when they tried the civil case, there was an email sent by one of the Los Angeles police officers regarding that case back in 1991. Here it is, quote, "Oops, I haven't beaten anyone so bad in a long time." Okay? Now, how do you think that played out in court? Well, we all know how that played out, okay? Or if you remember the Rodney King event, you know how that played out. And Rodney King ended up with a great deal of money. So, so you've got the employer who may really want to be able to monitor its employees' emails. On the other hand, you may have laws that say you can't. For instance, if you're governmental, you've got the Fourth Amendment. Some states limit what you can monitor and what you want. There's also what we call a common law invasion of privacy. All right? So you may have a federal law, or you may have a state statute that prevents it. You may have a federal law, such as the Fourth Amendment, or a constitutional law, that prevents you from monitoring emails. Okay? You may also have just what we call a common law of privacy. And let me give you the elements for a common law of privacy. All right? In order to have a common law of privacy, a lawsuit regarding the common law of privacy, to determine whether an employer has violated somebody's privacy, if you will, you have to prove 5 different things. And they are as follows. You first have to prove that the facts disclosed are private. Okay? That the facts disclosed are private. You then have to show that the disclosure of those facts were made to the public. Facts disclosed are private. Disclosure was made to the public. Third, the disclosure is one that would be highly offensive to a reasonable person. Highly offensive to a reasonable person. Fourth, that the facts disclosed are not of a legitimate concern to the public. And 5, with reckless disregard of the private nature of the facts disclosed. Okay. So, back to the beginning. Facts disclosed are private. Disclosure is made to the public. Disclosure is one that's highly offensive to a reasonable person. Facts disclosed are not of a legitimate concern to the public, and the defendant acted with reckless disregard of the private nature of the facts disclosed. All right? So, give me a situation where, as an employer, I may be invading somebody's privacy based on those kind of elements, just in general. Day? I'm sorry?
Email?
Yeah, and email, and be more specific. I mean, let's lead you there a little bit, okay? I monitor Day's email, and I say, oh, look at this. Day went to McDonald's for lunch, and I spread that throughout the company, okay? Invasion of privacy or not? And why not?
Because anybody could have seen you go to
One, anybody could have seen her go to McDonald's. All right. So I'm not sure she has a legitimate expectation of privacy with regard to where she's gone to lunch if she goes for McDonald's. All right. Why else?
It's not offensive.
Well, probably not. No, I agree with you, Lisa. Okay. Now, they may find it really offensive. I don't know. All right. And Monday nights is usually, I don't eat dinner till after class. So it's like McDonald's is frequently where I end up going. And I'm not a big fan of McDonald's, but it's quick and it's drive-through and I can eat on the way home. So, but no, Lisa, you're right. It's not generally offensive. Okay. Any other reasons?
It's not a concern of the public.
It's not really a concern, although that would be a reason why, that would be in the element though. Okay. So that would actually be one of the reasons it would be an invasion of privacy, because it really is not anybody else's concern. You with me on that? Okay. All right. Any other reasons? All right. Now, we've given that email. Now, somebody give me another email. So that's probably not an invasion of privacy. Somebody give me another email where it would be an invasion of privacy.
If your doctor emails you some sort of lab test result.
Okay? You got a doctor who emails a lab test result, okay? And one of the examples in the book, and by the way, this invasion of privacy, I will tell you, very, very hard to prove. There are a lot of states that look at cases, but very, very hard to prove. But doctor tells me that I have a disease, okay? And let's go back. We've used AIDS, I think, with a doctor earlier tonight. All right. So let's go back to that situation. If a doctor, if I know I have AIDS, all right, and that doctor tells me that I have AIDS, and he may be violating all kinds of other laws, but I may have a lawsuit if he takes that and then emails it to my employer and says, by the way, Greg has AIDS. Okay? Now, and why would that be a violation or a possible invasion of privacy?
Doctor-patient confidentiality.
One, you're going to have some problems over and above, okay? And we'll talk about HIPAA in just a few minutes, but you're going to have problems there, all right? So get beyond HIPAA violations. You're right. Get beyond the ethical issues of a doctor-patient, but are those facts going to be generally private? Well, sure they are. There's all kinds of laws that make them private. He would have to disclose it to the public, okay? Is it going to be highly offensive to a reasonable person? Probably, okay? If it were, and you may go, well, wait a second, having AIDS shouldn't be highly offensive. Well, maybe that's right, maybe that's not right, but people with AIDS don't go around shouting about it, okay? So for the most part, it probably meets that test, that it's highly offensive to a reasonable person. Are the facts disclosed of a legitimate concern to the public? Little iffier there. It depends on the area, but probably not. Probably not, okay? And with a reckless disregard of the private nature of the facts disclosed, yeah, if he's just emailing it to whoever he wants to, okay? So there is an example where email may be an invasion of privacy. Bottom line is, you're going to win some privacy on the Fourth Amendment. You're going to win some privacy, and when I say win, the employers aren't going to be able to, public sector employers aren't going to be able to share information because of the Fourth Amendment. Private sector may not be able to share because of state statutes. Probably the invasion of privacy stuff's not going to prevent an employer from doing it unless it's high enough, sensitive enough that it comes into play. There are, however, a couple of acts that I do want to talk about real quick in this. One is the Electronics Communications Protection Act. The Electronic Communications Protection Act. Okay? Now, here's what this law says with regard to the monitoring of email. It is the unauthorized, it prohibits, let me back up. The Electronic Communication Protection Act prohibits unauthorized and intentional interception of wire, oral, and electronic communications during the transmission phase. Okay? And the unauthorized accessing of electronically stored wire or electronic communications. All right. If I get on to the computer that Day, let's say Day is one of our employees, and I get on to Day's computer that's at her workstation at our office, and I read an email that says she went to McDonald's for lunch. Have I violated the invasion of privacy? Have I invaded her privacy based on all what we talked about earlier? Going back to privacy, I'm jumping around just a little bit, but on purpose. Have I invaded her privacy? No, we already established that, okay? Have I violated the Electronic Communications Protection Act? Don't look at me for an answer. I'm asking you all the questions. Yeah, have I? Yeah, Amanda, why?
Because it was unauthorized.
All right? And we may disagree, okay? And again, same thing. If you see a scenario on an essay or something, I'm not as concerned that we disagree as I am concerned as to how you get there. You say it's unauthorized, okay? How many agree with Amanda? Or argue the counter? Lisa?
I agree.
You agree with Amanda. Okay. Somebody take a counter position.
I don't see that there's anything wrong with it because it's still your computer.
It's my computer, all right? So, I would accept, by the way, if you were to see a question like that, I'll accept either answer because what it tells me is you understand that it's unauthorized access and you say it's not unauthorized or that it is unauthorized access. You would say, hey, and so therefore it is a violation. You would say it's not a violation because it's not unauthorized access, all right? And both of you would come back to me and you would say, hey, this is not a violation or it is a violation because it is either unauthorized or it's not. I personally will agree with Melissa from the standpoint that it is an employer's machine, and for the most part, an employer can do whatever they want. Now, remember the interesting, was it the case in the text or in the back of the supplemental questions? I'm going to forget. Remember the guy who was working, I think it was in your text. Remember the guy who was working at, had a computer at home and a computer in his office? This may have been a supplemental question, the back of your text. There's a guy working at home. Let me just give it to you. You don't necessarily have to read it, but let me just give you the setup. Guy working at home, all right, and he has an office. The company provides both of those computers, and he signs an agreement that says company has the right to access it, both of them, and to get him back. He does some material, oh yeah, it was the porno sites that just pop up on his computer. He says he didn't go there, they just popped up, okay? And so company goes after him. He sues for invasion of privacy and violation of laws. Does he win or does he not win? Melissa, what would you say if we were just looking at his office computer? You would say no.
I would say no.
All right. Now, knowing that he also has the home computer that they provide.
I still say he doesn't win because he signed an agreement that
Okay.
it's still the company's computer.
Yeah, Melissa says he signed an agreement, okay? And for the most part, I think that's going to be the way it ends up. Although it's a lot trickier when you have a computer at home that somebody's going to be using for their own personal use as well, all right? But no, clearly unauthorized access of electronic stored wired electronic communications. Now, Amanda, let's take that first part of that definition, okay? Forget the unauthorized access of the stored communication, all right? Let's go back to Day. Find the email that she has on her computer or the office computer that says she's gone to McDonald's for lunch. Violation of the Electronic Communications Act then.
Wouldn't that be intentional interception?
Okay? It's unauthorized. We'll take the position that it's unauthorized, and we'll take the position that it's intentional. Why? Give me a reason why it's not. What's the rest of that? Make sure you get this. And I say you, I mean everybody.
I didn't get the rest of the definition.
Okay, all right, fair enough. Unauthorized, remember that first part, unauthorized and intentional interception of wire, oral, and electronic communications during the transmission phase, okay? So if it's just on her desk or the computer, and we don't have this unauthorized access issue, and it's not during the transmission phase, then it may be okay. All right? But that first part, keep in mind, that first part of that prohibition deals with the transmission phase while they're sending it. Melissa?
So if she just wrote it and didn't send it, you can't authorize, you can't look at it.
Yeah, apart from the fact that it's my computer. If we set aside the fact that as the employer, maybe I don't have the right to look at it. Okay, and some states actually prohibit what you can do. But yeah, if you set that aside and she just wrote it but never sent it, then it's not going to be a violation. Okay? Or if she sends it and I'm not intercepting it while she's sending it. Okay? Even if she sends it and it just becomes in that second part of that definition where it is stored, because it's going to still be stored even though she sent it. Okay? All right, any other questions about that? That's what basically the Electronic Communications Protection Act provides. All right, couple of exceptions. Number one is easy, the consent exception, where the employee gives consent or the person gives consent. We're talking about the employee situation here, but really that act talks about consent. All right. Where are most employees going to consent to that information? Yeah, in the employment contract or in the handbook. All right? May not even know it. You know, people don't read those employment handbooks. They look at them, they sign what's in front of them. They don't ever read them. But a lot of times, good handbooks have a provision that says you consent to us looking at your email while you're using office equipment stuff. Okay? The other exception to that is what we call the service provider exception. If a provider of the service is looking at it, that may be an exception. All right. Give you a case that I looked at and we decided not to proceed with after we did the research, but had a guy who was terminated from I can say this, from Altel, okay? And he was terminated from Altel. The reason he was terminated was a employee at Altel, a female employee at Altel, sent him a message that from her company phone, let me back up. By the way, when you, at least in these particular individuals, when you worked at Altel, you got two lines. You got an employer line, which was dedicated for business stuff, and you got an employee line, which was a perk of working at Altel, your own private line, okay? So you could do whatever you want. So a female employee at Altel texts this guy and says, hey, I need some drugs, and I don't remember the exact nature of the drugs, but can you provide them to me? And he texts back on his private line, yes, I'd be happy to. And then he texts back 30 minutes later, he got smart, I guess, and decided, you know what, that's not the right thing to do, so I'm not going to do it. Well, they're investigating her. They fire her, but through the process of that investigation, they read his emails on his Altel phone, and they terminate him. Okay? Looked at the case, decided not to take the case. Set aside the fact that he's stupid, I mean, okay, but why did we decide not to take the case?
Because it was on a private line.
Well, that was one of the, actually, Tom, that was one of the reasons Tom says it because it was on a private line. That's the reason we were actually going to take it, because it was on his own personal, it was on his own personal line.
I got the lines misconstrued,
Yeah.
I'm sorry.
Yeah, no, but it wasn't on the business line. It was on his personal line. So we almost took it. Why didn't we? Melissa?
Because it was illegal. He was.
Yeah, from a practical standpoint, I didn't think I could sell that to a jury. I just never thought I could get there. But why else? What's unique about Altel versus anybody else?
They're providing that line.
They're the service provider, all right? And we're still not confident how the courts would rule on that, but that was like, this is not the case we want to go up to the Supreme Court and see how they do. So decided not to. Okay. So service providers, remember the consent. Employees can give their consent and frequently do when they have a handbook. Service providers have an exception as well. Now, many states we talked about have their own laws. This Electronic Communications Protection Act is a federal law. Missouri has an act very similar to that. Okay, Missouri has an act very similar. Again, consent is an exception. All right, so if somebody gives their consent. Here's the problem, and I say the problem with the act, it's probably a pretty good act. But Missouri's law doesn't appear to give any discretion for damages. The damages for Missouri are $100 a day or $10,000, whichever is greater. Tell you what happened, I was not very happy with the other attorney. I got involved in the case after the lawsuit developed, but husband and wife were getting divorced. And one of the reasons that the husband was getting divorced is because his wife was having an affair with Barry Manilow's drummer. Okay? And he, during the course of the divorce, that came out. And they asked him, well, how do you know that he was having an affair with so-and-so? And he said, well, because I went to a private investigator and I bought this gadget and I was intercepting her telephone conversations and her emails. And they go, okay. And then they settled the divorce. Now, his attorney, and just as a practical matter, make sure you clear up all loose ends, his attorney should have gotten a full release and said, hey, when we get divorced, we're all done, nobody's going to come back after the other, etc. They got divorced. A week later, 2 weeks later, the wife now turns around and sues, not wife, ex-wife, now turns around, sues her ex-husband for what? Yeah, invasion of privacy and violating Missouri's law regarding interception, okay? Because he has done it. Not only has he done it, what else has he done? He's admitted it, right? Okay? So how's he going to win this case? He's not. And what I told him. Now, I thought he would make a sympathetic witness to a jury. So what we did was say, you know what? Missouri statute says $10,000. Here's what you're going to do. You're going to make an offer right now, and there's a formal procedure for that. But we made an offer of $12,000, $13,000, right around there. And we said, here's $10,000 for the law, and here's $2,000 or $3,000 for the attorney fees and court costs and all of that. And we made it 30 days after they filed the lawsuit. Said, you got to do it because you're going to lose, but I'm willing to bet no jury will give you more than $10,000 in damages. And if it's more than $3,000 in attorney fees, you'll be fine. And they didn't accept it at first, but eventually they came around because they understood, hey, we're going to lose this. He's offering the $10,000. We're not going to do any better than that. But if you think, if you're monitoring people's stuff that's not on your equipment and you're intercepting that as an employer, that's a serious problem. All right? Now, can you monitor their emails? Probably, because it's not an unauthorized access. However, If within those emails they happen to give their password, can you take that password and then get into their Gmail account or their Yahoo account or whatever? No. No. Okay? Because now you've gone an extra step. You've not just monitored what's on their machine, you've taken that information and used it to intercept other information. See the difference on that? Okay. All right. So that's the statute on that. Book, HIPAA. Any questions on those? Any question on either the Polygraph or the Electronic Communications Protection Act? Jackie.
So this is a little off topic for the employment situation.
Okay.
But for that husband, I mean, if he made an argument that he was the one, like say she didn't work, if he made an argument that he was the one paying for their phone service, could he still be in trouble for looking at her messages and whatnot?
It's Missouri State calling me. Sorry.
Ironic.
I do have to keep that on because I never know when an emergency for work's going to happen. But I'm sorry, Jackie, what?
No, it's if he made an argument that, for example, like his wife, or when she was his wife, she didn't work, and so he was the one paying for their cell phone service, and then he was like kind of the provider.
It would make, as a service provider?
Yeah.
Yeah, but he's not the service provider, okay? That's a nice twist on that. But no, in order to be a service provider, you have to actually be furnishing the lines. It's technology. Okay, that's a great question. Yeah, you have to actually be furnishing the lines. The other thing is she had her own separate account. One of the things that he may have been able to argue, if the facts had been right, was, hey, that's my account. Let's say it was his account and she just happened to use it. Then he could say, no, it's my account. I'm not intercepting it. But it wasn't. It was her separate account. Yeah, Melissa.
Is there ever a situation that it would be okay to monitor someone else's email, like in a divorce case, like if you think the other person's like selling all your assets and you're trying to protect, keep, your $100,000 from being gone?
If you get in, if you can't do it without, the problem was, and he admitted it, the problem was he had first used keystroke. That's how he had gotten her information. He had used keystroke software, so when she logged in, he would catch her password that way. Okay? You can never do that. There's just, I don't care what and that's why I said, look, I'm not worried about it. You're going to have to pay the $10,000, but I'm willing to bet a jury will never, based upon what has happened here, jury's not going to feel sorry for her at all. This isn't one of those things that she sued you for from the very beginning. Instead, she files for divorce, gets 50%, now comes back and wants more on top of that, okay? And in that situation, he was still going to have to pay the 10. There's never justification under Missouri's law for intercepting unauthorized access. I think it comes down, a lot of it, to the unauthorized access. If it's his machine and he doesn't have to use passwords to get that information, I think it's okay. But taping the phone conversations, stuff like that, not going to be okay. By the way, just a point of kind of off topic here. Missouri, you only need one person's consent to a conversation. All right, so let's go back to the divorce. We're out of the employee situation for just a second. If I'm taping a conversation, let's say I'm going through a divorce and I'm taping a conversation with my spouse, nothing wrong with that, okay? If I'm and even if I don't tell her that I'm recording it, I can record it, okay? If, however, I have set up a thing to intercept her conversations with our kids, different matter, because I'm not a party to that conversation, okay? You may remember Monica Lewinsky. And who was the gal? Who was the great friend of Monica who turned her in? I don't remember her name, but you know who I'm talking about. She got charged with a crime for intercepting the conversations or recording the conversations because that particular state was not a one-party consent state. Both parties had to consent. And some states have what we call both parties consent. Okay? And if you intercept those conversations or record them or whatever without both parties knowing about it, then in those states, there can be a violation. Okay. Does that answer, Melissa, I kind of got off track there, I think, but does that answer your question? Okay. All right. Any other concerns or thoughts or questions with regard to either this Polygraph Act or the Electronic Communications Privacy Act? A couple of people, somebody said, well, hey, what if they buy your cell phone? And I thought it was a great question. If they take your cell phone, they pay you cell phone, do they have the right to monitor? I think if they're paying for it, the answer to that is yes. Okay, whether they're a service provider or not. And somebody else asked, can they just confiscate your cell phone? You know, if they're not paying for it, your employer probably doesn't have the right to confiscate your equipment. Okay, so if you're paying for it, then it may be a little bit different issue. Okay, may be able to subpoena it, subpoena records or whatever, but it's going to be a little bit different if they're not the ones who pay for it. Okay, all right, let's talk real quick the book, and I don't want to spend a lot of time on it. Then we need to move on to past privacy. But HIPAA, what is HIPAA? And I don't care that you give me what the acronym name is because everybody just calls it HIPAA now. But what's the basic purpose of HIPAA? It's a privacy law, Jackie.
To protect the health information of anyone.
Yeah, it really is to protect the health information, as Jackie says, of anyone. Okay, it's to protect the health information of anyone. Basically, this law, and I want to give you a little bit more than what we gave you in the text or in the supplemental material or the supplement material. It's a law that applies and says that basically covered entities cannot disclose healthcare information, certain healthcare information. Okay? I'm going to be pretty broad on it. That act is pretty big, pretty detailed, so we're not going to get into all that. But basically, it's a law that says certain covered entities cannot disclose and must protect private health information. All right? There are mainly three types of entities involved. Health plans, okay? Health care clearinghouses, and healthcare providers. Health plans, healthcare clearinghouses, and healthcare providers. Give me an example of a health plan. Anyway, John.
Would that be, would that be like your insurance?
Yeah. It's just your insurance. Most people that are employed, not all, many people that are employed have benefits and they have a health care plan through their employer. Okay? That's an example of that. It's your health care plan. It's United Healthcare or whoever it may be. It breaks down into more than that, but we're just touching on the surface. No way we'll dedicate all we need to on it. Healthcare clearinghouse. Anybody know what a healthcare clearinghouse is?
Is that where they sell your policy to someone else?
No, but it's the same idea, Tom. It's not necessarily where they sell your policy to somebody else, but they take your clearinghouse, takes all your information and compiles it. Okay, so they may not sell your policy, but they may put all that information together for either the health care plan or for somebody else. Hospitals may use it for medical records. In other words, they may take that information and say, hey, take this, compile it, and then send out a bill. Okay, so that's what a clearinghouse is. They put it all together. Okay, they may pay. There may be a payment arrangement. All right, so it's pretty close to that. And then what's a healthcare provider? Huh? Yeah, it's your doctor, your nurse practitioner. Okay. Generally, keep this in mind. Generally, HIPAA applies to plans with more than 50. I was going to say more than 50. We probably ought to say 50 or more because it does not apply to plans that are less than 50. Generally. Okay. Generally does not apply to plans less than 50. Okay. There is a provision if you work in this field and you need to, you'll need to know this, or if you work in a health plan or a clearinghouse or a provider, there is a provision that if there has been a breach, and if somebody has inadvertently sent out information, okay, or if you believe it's been accessed, you have to disclose that to the person, to the patient. Okay? So if there's a breach, you have to notify the person of that breach. Interesting, this law does not give a private right of action to sue. Okay? So, you're a patient, your nurse practitioner has shared that information with somebody else. You don't have the right to go sue the nurse practitioner. You make a complaint, and when you make that complaint, and you make it with a federal agency, when you make that complaint with the Office of Civil Rights, that's who you complain to, the Office of Civil Rights, when you make that complaint, they will investigate. But you yourself will probably not get the funds from that. There may be fines, there may be penalties, but if you're the one whose privacy has been violated, if you will, or the law has been violated with regard to you, you probably don't have a private cause of action. We represented, one of the entities that I represented was a fairly large hospital in town, and we would sometimes do their collection work. And interesting, we didn't always know when spouses were no longer spouses, all right? So at the time they got their services, they may have been married, but since split. And we didn't know that, and we would file the lawsuits together. And it happened on more than one occasion where they were now exes, and one spouse would say, well, you've sued me in connection with a medical bill, and you violated HIPAA, and now, you owe us all this money. It's like, just go file your complaint. First of all, there's an exception, which I didn't tell you about, and I'm not concerned that you worry about, but there's an exception if there's a lawsuit to collect medical bills. So HIPAA doesn't even apply at that situation. But we weren't really too concerned about them suing us for that reason. Now, most employers that aren't health plans, clearinghouses, or providers are really not subject to HIPAA, all right? So, if you have your regular, let's pick on you, Whitney. If we have your company, all right? Probably not subject, for a lot of reasons, because of the number of employees, but probably not subject to HIPAA. Having said that, you don't want to go disclose it. Because even if you're not violating HIPAA, what may you be violating?
Well, that person's privacy.
Privacy. We may get back to the invasion of privacy, and there we may get into that invasion where we talked about those 5 elements. Okay? So even if you're not violating HIPAA, and most private employers that aren't one of those 3 frequently or not, you certainly don't want to do that. Okay? A couple of other, any questions on HIPAA? I know we go through that pretty quick, but we could spend forever on HIPAA and not cover it. Okay? There are some privacy concerns with regard to employment law, labor discrimination. All right? Patriot Act is also a concern. And Patriot Act allows, or requires, I will say, certain employers to take certain steps. Melissa, you're in the hotel industry, right?
Mm-hmm.
Do you know how the Patriot Act affects you in particular?
Well, we can't disclose any type of information about guests or.
Okay. All right. Recently, and there's been some discussion that, for instance, hotels have to match their guests with the watch list, okay? So every day, Homeland Security puts out a watch list of these people. And under the Patriot Act, there's some argument that hotels are supposed to take the names of their guests for that day and match them with watch list given to see, and if they find a match, turn it in. All right. Same thing with banks. Banks are supposed to check certain information, match it, find it, turn it in. Amanda.
I was just gonna say that, I work at a bank and it's called Office of Foreign Assets Control.
Right.
And it's a list of people we can't do business with.
Right. Yeah. There's and that's so the Patriot Act. It has a lot of different things where it has affected and given up. It's actually a law that it gets away from privacy as opposed to most of the laws that we've talked about discussing privacy. So, any questions about HIPAA? Okay, next class period we'll talk about restricted covenants and trade secrets.